appeal to a decision determining their age? And what about free legal assistance of children? We have received no very comprehensive reply from the state, so I would like to put it again and ask the state party to provide clarification as to whether Maltese legislation provides for legal assistance for this vulnerable category of persons, unaccompanied minors. If possible, would you have any examples to provide to the committee? Any statistics that you can quote on the number of children that have been able to benefit from these services, notably free legal assistance? And finally, Chairman, on question 16, relating to measures taken to fight or to combat Corridano and Leicester and Safi barracks, the conditions, the poor holding conditions there, and the open prisons as well as the improvement of conditions in the Moncarme hospital wing. Now, the question put to you had been whether those who had already been sentenced were held separately from other detainees. And is there any separation between those who are sentenced to lengthy sentences and those who are sentenced for short periods? And there are also questions relating to illegal migrants who commit offences. And there were also questions about efforts made to improve the living conditions within all prisons. In response, you've told us about the new measures in place in detention centres with respect to migrants. There have indeed been many improvements. And these measures have on many occasions been taken as a result of financing from the European Union. I'd like to thank the state party for all the information it has provided, and I think this speaks volumes about your intent to comply with the covenant provisions. However, when it comes to the separation of prisoners who have already been sentenced and those who are still on preventive detention or on remand, when it comes to this separation, if I've understood you correctly, at the moment there is no such separation between the different categories of detainees, because you tell us that there's a separation between men and women, between adults and children, and also that you hold persons with psychological problems separately, but no other kind of separation. So in future, do you intend to envisage the possibility of holding these different categories mentioned by me earlier separately? And what about provisions for illegal migrants who are in these holding centres? A question was asked, and in your reply, you said simply that these migrants were subject to no disciplinary proceedings. So my question is this: what measures could be taken against these detainees if they break the rules of detention, if they attack, for example, the other detainees or the officials guarding the holding centres? Thank you, Chairman. Thank you, Mr. Bouzid.
Speaker on my list is Mrs. Zlatescu. Mrs. Zlatescu, you have the floor, sir.
Microphone, please, for Mrs. Zlatescu.
Is it okay now? Yes. I want to thank you, Mr. Chairman, for giving me the word. Thank you to the distinguished delegation for providing these clear answers, and also for taking the burden of dealing with such unusual situations, such as the immigrant of African migrants and refugees, yes, on its shores and in its system. And since Mr. Bouzid has addressed so many of the questions related to the detention of children, including here teenagers, I would align to his question in detailing, yes, some of the things that I think should be asked in open here. In the course of a virtually ready-made detention procedure, the state of Malta habitually detains unaccompanied migrant children whose age is not known until their age status is determined, yes? How is their age status determined? And how long does this initial procedure keeps them in detention facilities? Unaccompanied children are often teenagers. This is under the age of 18, typically between 14 and 17, who migrate without parents or caregiving adults, as we know. The habitual detention periods for minors range between 3 and 7 months, followed by their potential accommodation in an external facility. While most children who are accompanied by their families are rapidly relocated from detention to open sites, we understand, unaccompanied migrant children are held in detention for extended periods. If this has changed, please update us on this, because our reports are 1 to 2 years old. Anyone who is not visibly a child will be detained in what seems a rather long threshold in the application of the law, willingly or not. We do understand exceptional circumstances here. For the period of confinement, our info showed children shared the often overcrowded premises with adults. Please confirm if this is actual or not, without any special amenities for minors, instructional facilities or caregiving policies directed at them. And this follows Mr. Buzit's question, which can add to their existing traumas and turn them into potentially unadapting individuals. Our information showed that Malta does not make an exemption from the arbitrary detention policies when it comes to the most vulnerable migrants. Is there an assessment mechanism in place? Maltese authorities also take to detention families with children, old people, and migrants who display either psychological or physical disabilities, though most are freed before 12 or 18-month time. One of the disabilities should be related to their ability to understand, yes, and to value their situation as and knowing of their rights as migrants, irregular migrants, since many of them do not know about Malta at all, yes, or why were they rescued by Maltese forces. They just look for a safer shore along the European Union's coast. Now, my question for the distinguished delegation is, if Malta is intending to ameliorate its treatment to those vulnerable migrants, or if it has done it already, especially to those who claim to be children, as such putting on hold the outcome of age determination proceedings and freeing from detention all those with pending claims. Thank you very much.
Thank you, Mr. Zatescu. The next speaker on my list is Mr. Shani. Mr. Shani, you have the floor.
Thank you, Chair, and I wish to join my colleagues in welcoming the delegation from Malta and thanking them for the responses we have heard so far. I wish to elaborate very briefly on a law-related point which was mentioned by my colleague Ms. Majodina with respect to Article 12 in the list of point number 12 in the list of issues. Now, the question is, can you explain to us on what legal basis do you justify the position on jurisdiction specified in paragraph 56 of your response to the list of issues which contest jurisdiction of a persons rescued at sea, specifically with the incident of 17 July 2010 in mind? Am I right in understanding that the claim on the facts of that incident is that these persons never embarked, even for a short period of time, on ships hoisting the Maltese flag? And if so, I don't understand the relevance of the claim that you have made that the rescued persons have, and I quote, have knowingly chosen to be rescued. And more generally, I would like to know whether it is the general claim of the state party that search and rescue ships generate for the flag state no responsibility under the covenant vis-a-vis individuals that they rescue at sea. And if so, how do you reconcile this with General Comment 31 of this committee on the nature of the general legal obligations of the state parties, or for that matter with the case law of the European Court of Human Rights on jurisdiction and sea? I'm thinking of cases such as Medvedev and Hirsi, for that matter. Thank you very much.
Thank you, Mr. Shani, and I think that's the last speaker on the list. So I now turn to the delegation, recognizing that they'll have a little bit of internal consultation to do before beginning their responses. And also perhaps recognising that they may need to continue tomorrow morning, since it won't be possible for us to continue past 6 o'clock. So The delegation is about to begin its responses, colleagues. With renewed thanks for their diligent consultation to respond promptly to our questions. The floor's with His Excellency the Ambassador. You have the floor, sir.
Thank you, Chair. Given the amount of questions that were included in the overall reactions we had, I propose to address each question specifically, or each set of questions done by each person that intervened specifically, if there is any overlap of questions being answered in the various questions that follow up, please bear with us. But there are areas which tend to overlap, and therefore one may require also to mention them again. So, first question, violence against women, by Ms. Waterfall. You've mentioned women shelters and whether there are, whether we have statistics on the number of available shelters for women. I give the floor to the expert from the Minister for Family and Social Solidarity.
Thank you. With regards to issue number 9, you may wish to know that in 2008, the Commission on Domestic Violence embarked on a research study entitled Perceptions of the Maltese General Public on Domestic Violence. The main objective of this study was to provide a synopsis of the perceptions on domestic violence among the Maltese general public. In 2010, the Commission on Domestic Violence embarked on a new funded project entitled Dignity for Domestic Violence Survivors, which contributed towards the capacity building of personnel working with vulnerable groups in order to increase social cohesion. This included work on empowerment of the victims by enabling them towards effective participation, inclusion and well-being. Inclusion into the labor market ensures that victims living with or escaping from domestic violence are able to better contribute to the general wealth of society, while enhancing their dignity and financial independence. This project also aimed at building networks among NGOs and other agencies to share best practices and experiences. Moreover, a protection order is issued by law courts in Malta on domestic violence cases. Women's shelters are also available for those victims and their children who have left the household due to domestic violence. Currently in Malta, 5 women's shelters have been established. In addition, Agencia Poch, which is the National Agency for Children, Families and the Community, has offered social work interventions within its domestic violence unit and also organized immense services for perpetrators of domestic violence. Victims can also be referred for further psychological help with the same agency or programs for men to deal with violence issues. Thank you.
A question was raised concerning the indication that tables indicated 0 investigations. I would ask the expert concerned to elaborate on this matter. Carmen, for 0 investigations. Elaborate on that.
Well, it could be that investigations, maybe the police are still gathering information on the case presented, and maybe that's why there is no arraignment so far, if I understood correctly your question.
We'll skip to the questions by Ms. Jabet 4. First part of a question addressed the right to life. Well, our position has been clearly specified also in our introductory statement. However, for the purpose of clarity and completion, I will once again identify what the position of the country is in this regard. With respect to abortion, the government of Malta respects all of its obligations, including its international obligations. In cases where the life of the mother is at risk, clinical situations are managed on a case-by-case basis by the clinicians who try at all costs to save the life of both mother and child. Interventions to save the life of the mother, even if this means that as a result there is a chance that the child will die, are not precluded, but no intervention that directly kills the child is allowed by law. Now, concerning the review of legislation of abortion and exceptions that should be made to the general prohibition in cases of rape, incest, and therapeutic abortion and education, Malta continues to sustain that the right to life is an inherent right of every human being, and that this right also includes the unborn child. The right to life is enshrined in the Constitution of Malta. Malta believes that human life begins at conception and therefore considers the determination of pregnancy through procedures of induced abortion at any stage of gestation or for whatever reason as an infringement of this right. Malta therefore cannot recognize abortion or any other form of termination of pregnancy as a legitimate measure of family planning. Malta is committed to the promotion of sexual and reproductive health and to the protection of the right of women to have control over and decide freely and responsibly on matters related to their sexuality and the timing, number, and spacing of children free of coercion, discrimination, and violence. In this respect, we are also committed to the dissemination of knowledge, including information on safe and effective methods of family planning, to enable women and young girls to make informed and responsible decisions on matters of sexual and reproductive health. These principles, together with the values of respect and dignity towards human life from the moment of conception, and the belief that the stable family unit is the cornerstone of a healthy society, respectful of social, sexual, religious, and cultural diversity, underpin the National Sexual Health Policy launched in November 2010. The launch of the policy was followed by the launch of the National Sexual Health Strategy, which was formulated through widespread consultation with all entities, sectors, groups, and representatives of the entire society. The strategy sets out the targets, goals, and deliverables regarding sexual and reproductive health that are to be achieved over the coming years. As a follow-up, an implementation group chaired by the Superintendent of Public Health and including various stakeholders from government entities, including the Health Department, the Education Department, the National Youth Agency, as well as a member of the public, was set up. The terms of reference of the implementation group are: 1. To establish priorities for the implementation of the various measures in order to effectively achieve the full implementation of the strategy targets. 2. To ensure that measures outlined in the strategy document are translated into concrete action plans with specific interventions within an established timeframe and budget. 3. To monitor and coordinate, where appropriate, the implementation of the interventions. 4. To ensure close collaboration and consistency of action between all stakeholders involved and in the implementation of the strategy. 5. To recommend and commission any research that may be required to fill any deficiencies in information that is considered essential to the implementation of the strategy. And finally, to keep track of existing or develop new surveillance systems to be able to monitor progress in achieving the targets identified in the strategy. Health education is an ongoing initiative which is mainly coordinated by the Ministry of Energy and Health, the Elderly and Community Care, and the Ministry of Education and Employment. In 2007, the government of Malta set up an Education Health Committee made up of experts from the Ministry of Energy and Health and the Ministry of Education and Employment. The committee meets regularly to discuss and coordinate school health activities, to review existing health programs and initiatives taking place in schools, to advise and put forward proposals for health, including sexual and reproductive health, content of the national curriculum framework for schools. A number of sexual and reproductive healthcare services are freely available within the national public healthcare system. These include family planning, safe motherhood, infertility treatment included assisted reproduction, prevention, confidential testing, diagnosis and treatment of reproductive tract infections and HIV/AIDS, and also prevention and treatment of reproductive cancers and maternal morbidities. Furthermore, the Ministry for Energy and Health provides a genito-urinary clinic which offers a confidential service of diagnosis and treatment of sexually transmitted infections and counselling and testing for HIV and other genital conditions not necessarily sexually acquired. Now, concerning the other part of your question relating to excessive use of force in detention centres, I pass the word to our expert from the Ministry of the Interior. Got 4 minutes. So basically, since time is not really in our favour, I would suggest that our expert from the Ministry of the Interior cover broadly all the issues that relate to the situation within the detention centres and all those elements which were mentioned in various questions in a complexive manner.
Okay, I'll try my best. Okay, I'll start with the alleged cases of excessive use of force in detention. There have been, as has already been mentioned, there have been 3 riots in 2011, 2012 and 2014. An inquiry was launched following the first riot, the one which took place at Lister back in 2011, and recommendations were made by the Board of Inquiry in relation to the improvements required in the detention centres in order to prevent, if possible, the recurrence of such riots. Unfortunately, another incident did take place in 2012 when the Malayan migrant died. Disciplinary measures have been taken vis-à-vis officers responsible, who have also been brought before the courts and are currently undergoing procedure for compilation of evidence before the courts. So criminal action is also being taken where those responsible have been identified. The last incident which was referred to is that one at Lister, which took place in February of this year. During that incident, although some injuries were recorded, there weren't any major injuries, only minor injuries, and there were certainly no deaths in this particular case. Although use was made of rubber bullets, even in this case they were fired towards the air and not towards the migrants. They were used mainly as intimidatory rounds. In fact, there were no serious injuries as a result of this incident. It bears noting that at the same time, Malta is gradually introducing reforms which affect its detention system. And one of the questions that was asked is whether these reforms will also affect those migrants who are detained pending deportation, because it was stated that these can be detained for up to 18 months. This is theoretically true for even the Return Directive, which Malta has transposed in national legislation, allows for a maximum detention period of 18 months. But there is an important but. the member state is obliged to conduct a periodic review of the need or otherwise for continued detention based on whether there are reasonable prospects of deportation. In fact, Malta is already conducting such reviews. During this year, we have already released from detention something like around 350 persons. 192 of these have been released after less than 15 days of detention, not 18 months. So the system is gradually changing. Right now, we are obliged to implement this system vis-à-vis persons who are irregularly present and who are not asylum seekers. However, in practice, we are also conducting the review in respect of asylum seekers, and this will be enshrined in our legislation once we transpose the Reception Conditions Directive. However, we started implementing this provision even before it became a legal obligation in order to start gradually adapting the system. So, okay.
I'm really sorry to interrupt the delegation and the particular distinguished representatives who's providing very, very responsive information that's very important to our evaluation of the situation. We do have to respect the stress and strain and working conditions of the interpreters, and for that reason I do have to call a halt to the discussion now, but we look forward to continuing tomorrow morning. So with that, thanking the delegation once again, the session is adjourned.